Okay, I'll probably mispronounce your name. Is it Bizer or Bizer?
Bizer, correct, thank you.
All right, Mr. Bizer.
Just trying to see where the microphone is. Is this?
No, it's that
That,
bar,
okay.
bar in front of you, yeah.
Testing, just wanted to check it out, thanks. Good morning, Judge Smith, Judge Ho, Judge Barker. My name is Andrew Bizer. I'm the attorney for Dr. Scott Crawford. Prior to the trial in this matter, the district court held on summary judgment that Dr. Crawford had standing to pursue injunctive relief at the Hinds County Courthouse. The judge also ruled that the Hinds County Courthouse violated the program access standard of the Americans with Disabilities Act. After a 2-day bench trial, the judge reversed himself with respect to the issue of standing, but maintained that the courthouse violated the program access standard. I'd like to begin with speaking about the standing as pursuant to being a juror and then standing as an engaged citizen. The trial court erred when it cited the Seventh Circuit case of Hummel versus St. Joseph City for the proposition that the mere possibility of being summoned again for jury duty is not sufficient to confer standing.
Because the facts under Hummel were considerably different.
Considerably different.
That the plaintiff, before filing suit, had not been called for jury duty, is that correct?
So to distinguish, thank you, Your Honor, to distinguish Hummel from the case at Barr, the Hummel case was a bit of a mess. There were 4 original plaintiffs. Some of them died, some of them had their cases dismissed. They added 5 new plaintiffs. 2 of those plaintiffs, Wright and Brandy Comer, had never even encountered the alleged violations at the courthouse. They alleged that they had standing to pursue lack of services for the blind, despite not even being blind. And then they had no proof that they either had been called as a juror in the past, that they were on the jury rolls, or that they were even eligible to be on the jury rolls. So in that case, the Seventh Circuit held that there is no concrete evidence that the plaintiffs have already been or will be called as jurors. And so if you contrast that with Dr. Crawford was called to jury duty in 2012, in 2015, in 2018 after he filed his lawsuit, in 2019 after the trial but before the judge reversed himself, and again just last month. So that's 5 times Dr. Crawford has been called as a juror.
So address standing if we were to hold, I don't know what we will do about it, if we were to hold that we don't look at the jury service after suit was filed, but only before. That of course, is the tougher case for you, so you can focus on that.
Sure, Your Honor. So the district court, besides the fact that Hummel is distinguishable, the district court should have analyzed...
Well, it's distinguishable, and we're not bound by it anyway, because it's out of circuit, so.
Yeah, yes, Your Honor, thank you. The Fifth Circuit, the district court should have followed the Fifth Circuit precedent of O'Hare and Herman. And so in those 2 cases stand for the rule that a prospective juror who is excluded based on a systemic practice has standing to pursue injunctive relief. So in O'Hare, we had Ms. O'Hare file the lawsuit challenging Texas's rule that atheists cannot serve on juries. And so that was a systemic practice, it's a rule. And the court didn't go into any analysis as to whether she had been called many times in the past, whether it was speculative to be called in the future. The court said, well, this is a systemic practice. If she's called again, she's going to encounter it, okay? And so that's what we have with respect to Dr. Crawford. I'm sorry, let me get to Herman, excuse me, I got ahead of myself, sorry. So in Herman, Ms. O'Hare sued again. Ms. O'Hare is a really interesting character, but she sued again based on the fact that she had this discrete interaction with Judge Herman in Texas. And what happened was she got called to jury again, and the bailiff asked her to swear that she would tell the truth. She said, I'm an atheist, I can't swear to tell the truth. So the judge called her to the bench and said, well, will you affirm to tell the truth? And she said, well, that still violates my First Amendment right as an atheist. And then the judge got angry, and no one worked together to try to figure out how can Ms. O'Hare say, I'm going to tell the truth. And so that never happened. and the judge cited her for civil contempt, and she spent 6 hours in jail. The Fifth Circuit held that that whatever the abstract merit of Ms. O'Hare's complaint, it springs from a lack of communication between judge and a prospective juror that is inherently contextual and episodic. So when we contrast those two cases with Dr. Crawford, the systemic practice here is the ADA violations. The systemic practice is what the district court held was that the courthouse violated the program access standard of the ADA. And that the plaintiff has demonstrated that this is talking about Dr. Scott Crawford, the plaintiff has demonstrated that there are no readily accessible restrooms for wheelchair users, and that the various architectural barriers in most, if not all, of the 8 courtrooms impede ready access by wheelchair users to program areas. So at trial, we proved that there are no accessible bathrooms. We proved that there's a step up between the gallery and the bar.
Wasn't there somewhere in the building a restroom? Might not have been convenient or nearby, but there was, in fact, at least one.
Sure, that's correct. The main bathrooms had the accessible, the symbol of international accessibility. You know, the guy in the wheelchair. Those restrooms were not accessible. So the first day, Dr. Crawford soiled himself, thinking there were no accessible restrooms. On the second day of jury duty, he was like, "I'm not going to stand for this again," and started asking questions. Turns out there was a restroom behind locked doors. He had to get taken there by a bailiff. The bailiff had to sit there and wait for him to do his business, and he testified that made him feel infantilized. I don't know if I pronounced that word right. But yes, there was a bathroom that he could use on the second day. But the court held that it lacked program access. And so program access under the ADA deals with Title II cases against governmental buildings. Title III cases against privately owned, they have to strictly follow the ADAG. You know, you've heard of the cases where, you know, the mirror is 2 inches too low or the parking space is too wide. And so facilities that are owned by public governments, they have to comply with the program access, which is much more broad, much more leeway. So the question is, were the programs and services accessible to Dr. Crawford? And the district court held that no, they're not. So yes, there was a bathroom, but despite the bathroom, the district court held that the courthouse still violated the program access standard. And so we argue that this case is much more like O'Hare in that this was a systemic practice that caused Dr. Crawford to be excluded, as opposed to Herman, which is more of a discrete, individualized interaction. And in Herman, the Fifth Circuit, you know, discussed that and said, you know, what are the odds that with I think it was 500,000 residents and 20 court judges, that this particular woman, Miss O'Hare, is going to get in front of this particular judge, Judge Herman, and they're going to have the same miscommunication about how do you tell the truth. And so,
what do you think the odds have to be? If you could look at the statistics on jury service and population of a county and determine that a particular individual was likely to encounter a jury service call once every 20 years, 20, once every 20 years, would that be imminent enough?
So under O'Hare, once the Fifth Circuit realized that this was a systemic practice, that was the end of the analysis. There was no, will they be called again? What's the numbers? Is this speculative? There was none of that. In O'Hare, there was some of that because it was episodic. So I would argue that this court need not engage in some sort of numbers game and rule that because the architectural barriers are indeed systemic. When he gets called back to jury duty, he will encounter the same problems. The jury box is located up a step. All of the chairs in the jury box were bolted to the ground. So it doesn't matter how often he's called, when he's called, it doesn't matter how often he would be called or what the odds are. What matters is the systemic practice. And so, skip ahead to, and if I may just talk about the intent of where did this rule come from, right? And I think it meshes with the goals of the ADA. In O'Hare, what the O'Hare court cited, the Supreme Court's analysis of the 14th Amendment in the cases of Hoyt versus Florida and Hernandez versus Texas, which state that the 14th Amendment reaches not only arbitrary class exclusions from jury service based on race or color, but also all other exclusions which single out any class of persons for different treatment not based on some reasonable classification. And that's the same goal as the ADA. Under 42 U.S.C. section 12101B1, it states that the purpose of this chapter is to provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disabilities. So absent this injunctive relief, Dr. Crawford will be segregated from his local courthouse, contradicting the congressional intent of the ADA and also the 14th Amendment. So also, Dr. Crawford had an intent to return to the courthouse as an engaged citizen. As we all know, local courthouses are for more than just having trials and things of that nature. The Election Commission is in the Hinds County Courthouse. You can register to vote in the Hinds County Courthouse. Marriage licenses, things of that nature. And so the district court erred when it doubted Dr. Crawford's veracity that he intended to return by looking at his returns to the courthouse as an engaged citizen after he filed the lawsuit. And so it seems curious to me that for someone to say, I went to the courthouse as an engaged citizen to register to vote and to visit some friends who were getting their marriage license before the lawsuit. I filed the lawsuit saying I have the intent to return, and then after the lawsuit, Dr. Crawford did indeed return. He went to the Election Commission. And so for the district court to say, well, the post-filing visit is just a mere attempt to shore up standing, that doesn't make much sense to me, because if we just say it's a restaurant, you go to a restaurant twice, you encounter violations, you say, I want to go to the restaurant again. I want to go back to the Olive Garden, and you file the lawsuit saying you want to go back, and you indeed do go back. I don't see how that post-filing visit is not allowed to be evaluated, and that's what the district court said. The district court said that it was not going to look at that visit to give Dr. Crawford credit, so to speak. The district court was obligated to evaluate all the evidence put forth at trial. And courthouses are unique facilities. This is not like, it's really not like a supermarket or a restaurant. You don't know when you're going to be called back as a witness, as a juror, as a plaintiff, as a defendant, or you just want to go to see a big trial.
Well, anyway, it's undisputed that in a span of, you can correct me and be precise about it, but in a span of just a few years, he was called as a juror four times. Is that right?
Yes, he was called, yes, in the record it's 4 times from 2012 to 2019.
All right.
Yes. And no evidence was put on by the defendants by the county that he was knocked off the jury rolls, or that after that first interaction he had with the judge, that the judge went and said, well, this certain potential juror can't be a juror anymore. So it's akin to with the argument about returning as an engaged citizen. It's sort of akin to a music venue, right? If you go to a music venue because you want to see a band play and you show up and there's no wheelchair access, and you have a terrible time because you're looking at people's backs the whole time, and you say, well, I want to go back to the Superdome, or I want to go back to the Sanger Theater, or I want to go back to Tipitina's, and they say, well, when are you going to go back? Well, I don't know. I don't book Tipitina's. I'd like to book Tipitina's. That'd be a fun job. But a courthouse is inherently special, and I assume that your honors don't need me to explain to you how special courthouses are. But the intent to return, the district court erred by failing to take into account all of the evidence that was put forth at trial. And I see that 10 seconds left.
Yes, you've saved time for rebuttal. Thank you, Mr.
Yes, I did. Thank you, Your Honor.
Ms. Riley? Ms. Riley?
Good morning, Your Honor. My name is Katelyn Riley. First and foremost, I want to address some of the issues that I believe we have a difference of opinion on what the record actually says. The appellant has routinely reported that none of the restrooms and none of the courtrooms were accessible. Well, based on the plaintiff's own testimony at trial, that's not quite how it looks. In all actuality, the plaintiff...
Mr. Bizer has already answered that question this morning, hasn't he? Do you dispute anything that he said about the fact that there was, in fact, at least one restroom available?
No, Your Honor, that's my point, is there was one restroom available, but he did say that there were no accessible courtrooms. But there were accessible courtrooms according to the plaintiff's testimony, as well as the exhibits and review that the plaintiff had admitted at trial. In fact, Plaintiff's Exhibit 1, which is in the record as 2111, says while we did not have an opportunity to view all the courtrooms and all jury areas, we have noted unique barriers in each that we did view. Furthermore, they submitted multiple pictures of courtrooms in the courthouse, and you can clearly see from the pictures that there is some form of access to a majority of those juror boxes. So if we're looking at the juror box issue and complaining of that, the plaintiff likes to focus on the fact that the entrance gate coming from the front where a crowd might enter into the jury box, the gate is narrow. But to each one of those juror boxes, there's also a back door that the plaintiffs haven't made any allegation that wasn't wide enough for someone who's in a wheelchair and needs to be able to gain mobility in that sense. So there was access to that.
Is that a merits defense or a standing defense?
I'm sorry, Your Honor?
I'm wondering what, I thought we were here to talk about standing. It sounds to me that what you're focused on is the merits. Is what you're talking about relevant to the issue of standing?
Yes, Your Honor, because as far as his ability to show that he has future possibility or imminent injury, that's not quite the case, because the appellant has argued that if they ever go back, if he's ever called back to be a juror, as a prospective juror, or utilize the courtrooms in the courthouse, that he is going to encounter the same barriers. But that's not the case, because not every courtroom has those barriers. So there's the ability for those court proceedings to be held in the accessible courtrooms, depending on whether he's a juror or a witness, or whether he is a plaintiff in that case. So he's not always going to encounter those barriers. So therefore, it's not imminent that just because he goes back to Hinds County Courthouse, that he's still going to be injured. Just for the record purposes, there's also the other issue was saying that he was not able to go to the bench when called by the judge. But actually, they gave pictures, and they're in the record, at page 636, 638, 639, 644, 650, just to name a few, where the bench clearly wasn't lifted and someone in a wheelchair would have no issues going right up to the bench just as any other individual would. So they'd have full and equal benefits, the same as any other prospective juror.
What authority indicates that the court should consider that level of detail as to standing? That does seem like a disputed issue for the merits of whether that particular barrier posed a reasonable or unreasonable disability or barrier. How is that a standing issue? Doesn't he get to at least have his day in court on that?
I'm sorry, Your Honor, I didn't hear that last question.
Doesn't he get to at least have his day in court for a merits decision on whether that barrier is in fact an unreasonable impediment?
Well, Your Honor, in order to have standing altogether, he's got to show that he has a future harm if in place as a prospective juror. He's basing his standing on the fact that he will likely be a prospective juror in the future, and so he'll encounter those barriers. But not only is the fact that the argument that he'll be a prospective juror a bit speculative, the fact that he'll even have any harm once he gets there is even more speculative, because you would have to be sent right back to that exact courtroom on the assumption that it had not been remedied in any way.
You're using harm to mean a violation of the ADA, but for standing, doesn't harm just mean something that the plaintiff would find a hardship because of his disability, and then if that exists, then he's entitled to a merits determination of whether that violates the ADA?
Your Honor, my understanding is that once he seeks that relief, it's more than just having an injury all in of itself. He has to have a real or immediate threat that the plaintiff will be wronged again. And in this case, his version of being wronged again was in the event that he's called to be a prospective juror, then he would also have to be then selected as a juror to encounter these barriers. Or say
Well, to be selected, he'd have to be able to, operate the door with the doorknob that he alleges is an unreasonable barrier, right?
Yes, Your Honor. Now, there's multiple doorknobs that have different outcomes in this case. Some of those doorknobs have been fixed, and the plaintiff even has conceded these issues. Now, when a jury is escorted by a bailiff through each process, they lead them to where they're going, they open doors. Those are small fixes that could be made that necessarily might not, impede him at all. But that's if he becomes a juror. And see, the reason why it's such a big if is on 3 occasions the plaintiff has been called as a juror. Now, the first time in October 2012, the plaintiff arrived, had to relate. It was Judge Green's courtroom, which is a famous courtroom in many movies. And Judge Courtroom does have a slight rise, like the bar, when you step across the bar. Well, he was unable to get over that bar, so he had to have a bailiff relay his information to the judge. Now, the judge had asked, is there any reason why someone could not be able to serve? Well, according to Dr. Crawford's testimony, he testified that he had a medical condition that was going to leave him where he could not serve on a jury if it was going to be more than a few hours or more than a day or two, depending on whether his deposition testimony, his declaration, kind of varies, but it all generally amounts to he can't serve for extended periods of time. Okay, so as a result of that, he was excused. Now I know, and then on June 2015, same scenario, same things occurred, he was again excused. Now the only difference is the May 2018 time that he was summoned for jury duty, that occurred after the suit had already been filed. And in that case, his excusal had nothing to do with his inability to serve due to his condition. Instead, that was because he had a lawsuit against Hinds County. In fact, that was the reason why he was excused. And while the appellates have contested that we have no idea why that Dr. Crawford was excused on any of those days, Dr. Crawford has testified that he was excused due to his medical condition that would prevent him from serving. So the issues with the jury box and the doors to the jury box, all of those are issues that it's very unlikely that Dr. Crawford's going to ever encounter.
So here's what the district court found, as you know. District court said, plaintiff has demonstrated that there are no readily accessible restrooms for wheelchair users and that various architectural barriers in most, if not all, of the 8 courtrooms impede ready access by wheelchair users to program areas. Do you contend that that statement is clearly erroneous? Why don't you dissect that statement for us and tell us what your client's position is as to whether that's a reliable finding based on the evidence after a bench trial?
Yeah, a lot of those barriers that the plaintiff has offered as barriers, based on the report that was submitted at trial, a lot of those barriers are things that the plaintiff admits could be fixed with just moving some furniture around in the event that they had somebody who was in a wheelchair in the courtroom. But there was also testimony that there are attorneys that practice in a wheelchair and have had access in that room with no problem.
What I'm asking you to do is focus on the statement I just read you. I understand that there's more to the case than that. Focus on the statement that I just read you and tell us whether you think that statement was in whole or in part clear error, or whether your client accepts it as a legitimate reading of the evidence as Judge Lee saw it.
Your Honor, I'll have to ask you to read the first portion of it again. I could not hear the beginning of it.
Okay, I'm sorry, we do have sometimes some
Sorry, there's
audio
a lot
problems.
going
Yeah.
between us.
Okay. Quoting, plaintiff has demonstrated that there are no readily accessible restrooms for wheelchair users, and that various architectural barriers in most, if not all, of the 8 courtrooms impede ready access by wheelchair users to program areas.
Well, based on the evidence, it depends on what restrooms the court is referring to at that point in time. It just says, to restrooms at that time, because there are restrooms, as the plaintiff has admitted, that are readily accessible and available for someone with mobility issues. I do not believe that was a clear error in the testimony, but it doesn't do anything to change standing, because still he's not going to continue to, whether or not that was right or wrong, in that actual factual finding, it's not going to change standing, because even if those things were true, he still has standing, because it's unlikely that he's going to be called again to actually encounter those things. It's speculative to base his standing on the fact that he might be called as a juror, he might be called as a witness, he might be a litigant in a claim in which he admits he has no pending claims at this time. He has no claims where instances in which he's going to be called as a witness that we know of. The way the plaintiff describes it is, one day when the need arises, if it ever does, he'll go to the courthouse. I believe specifically it's when he is drawn and the need arises. That's his only future intent, and that's not concrete and particularized enough under the Fifth Circuit's prior rulings.
As you know, standing must exist for each form of relief that a plaintiff obtains. Are you suggesting that even if the plaintiff had standing to pursue and obtain relief as to some of the, common areas, like restrooms and doors, that he lacked standing to obtain injunctive relief as to all of the courtrooms, because there's only a speculative chance that he'd visit any one courtroom? In other words, would he have standing as to one of the courtrooms but not all of them? What's your position on that?
I think it's more based on the elements of the courtroom, what his purpose is there. If his past injury that he alleges of not being able to fully participate as a prospective juror, then his issues there were not having a wheelchair cutout. His issue there was the high rise that prevented him from speaking to the judge in the same way. Well, that's not presented in every courtroom, as the record clearly reflects. So that's going to be where his injury is, and he can't prove that is going to be a continued injury. That was one episode.
If you were to assume, for sake of questioning only, that the plaintiff had standing to obtain some form of injunctive relief, at least regarding common areas, on the theory that there was a non-speculative possibility that he would be called, what would that do for standing regarding the courtrooms? Would you pick the most accessible courtroom that he still claimed was illegal and say he has standing for at least that, but not the others? Are you drawing that fine of a line, or are you making a broader argument just about the likelihood of him being called back to the courthouse for jury service ever?
I'm sorry, can you repeat that last portion?
Are you drawing that fine of a line, or is your argument based more on the probability of jury service at all?
It's the probability of jury service at all, considering that he hasn't been called in quite some time, and but also the fact that there have been courtrooms that are accessible. So even if he happens to be called in the next 10 years, there are courtrooms that the proceedings could be held in that he would not incur those injuries. He would be able to approach the bench just as any other prospective juror would and relate in just the same way. So that injury is not going to be there. But as for...
And the district court's standing opinion was not based on that level of detail, though, was it? It was just based on the broader understanding about the speculativeness of him ever being called back and how much speculativeness the law allows, citing the Hummel case, correct?
Yes, Your Honor, but the law has given us some guidelines and factors, and as far as the factors go, those do not go into Dr. Crawford's favor any more than, so the 4 factors for the proximity test on the intent to return, yes, the plaintiff lives very close. Within a
This is a question no advocate likes to hear, but if you were to lose on the prospective juror issue, how would you like to lose?
If we had to lose on the prospective jury issue, it would be to the extent that it was reasonable for not every courtroom. It's a very historical courthouse. It's beautiful. It would take a lot of money and ruin the value of that. I mean, it's been in movies. It's the most beautiful courtroom in Mississippi, in my opinion, and in a lot of people's opinions. In our capital city, it's very old. It's the go-to. It's Senior Circuit Judge Tommy Green's, and I feel like there are other courtrooms. If we're going to alter or amend or do anything, it needs to be the ones that were, more recently built, the ones that don't have the wood and grains and all the traditional courtroom looks and appeals.
Pardon my ignorance. Are these courtrooms assigned to particular judges in particular courts, I guess?
They are, but at trial.
They are?
They are, but at
So is the
trial.
implication then of what you're saying that he could have jury service depending on which court? He'd be able to participate in a jury if it's one court but not for the other. One judge but not the other.
Well, at trial it was testified to that a lot of times when they're going to have a large group, they'll bring them into Judge Green's courtroom, regardless of who the sitting judge is for the trial, because that is the largest courtroom. But other times they conduct them in smaller types. They've been conducted in front of Judge Gowans when he was there, Judge Kidd's courtroom. There's a justice court level. They do it in each courtroom, and the judges, it was testified that the judges will switch around on need base, depending on, they might get a courtroom that's bigger because they're going to have a lot of litigants on both sides, versus the other judge might have a trial going on that has just merely 2 different parties. So they have their assigned courtrooms, but it's a very mobile use of them.
And, for what's worth, I'm not unsympathetic to your concern about the beauty of the courtroom.
I'm sorry, I
I'm
can't.
not unsympathetic to your concern about, your client's concern about the beauty of the courtroom. I guess I'm wondering if that is really a quibble with Congress. I mean, the ADA, after all, does require structural changes when there are violations.
Well, historical courtrooms aren't required to be in complete compliance to ADA. They have to be adapted to the extent possible to keep their historic value. The real problem is the expense and cost it is to make some of the changes to these historic courtrooms.
But again, isn't that a quibble with Congress? It sounds like that's a dispute about whether the ADA should be the law, not about the interpretation of the ADA.
No, Your Honor, because the ADA allows for reasonable alternatives to be provided and reasonable accommodations to be made. They don't have to completely redo a courtroom to be in compliance with the ADA if they do have accommodation and other ways to accommodate that person.
One brief procedural question. I understand the district court, you lost on the merits, sort of inverted. You lost on the merits but won on standing. Are you here to defend your standing win or to additionally attack your merits loss?
I'm here defending our standing win because.
So if that's what I thought. That's what I thought your brief focused on is standing and not the merits. If hypothetically, not previewing, if hypothetically the court were to find standing, what's the proper next step for our court?
If the court would find that he still has standing.
Do you send it back or we render on merits?
Your Honor, my understanding would we'd send it back for another trial on the issue of standing, and at that point in time,
On the issue of merits.
I'm sorry?
If we were to find standing, we'd send it back. You're saying we would send it back for a trial
And
on merits.
we'd on the merits, and at that point in time, Hinds County would be able to fully put on the evidence again that they don't have the money, and it's not reasonable and feasible for them to do every courtroom to the extent that the plaintiff.
In other words, you don't think you're bound by the merits loss. You would get a second bite at that point.
Yes, Your Honor, because there's plenty of Fifth Circuit cases saying, look, they present their financials, here's what we can afford to do, and if we don't have the money to do it, and you put that on, that is a defense to any requirement to making those changes. Your Honor, with the last 15 seconds that I have, I just want to say that in all the injuries that the plaintiff alleges that he suffered as a result of being called as a prospective juror, they had to do with his medical condition and being excused, and the fact that he had ongoing litigation. They had nothing to do particularly with architectural barriers. That's not why he wasn't selected as a juror. So therefore, he wasn't injured. Thank you.
Thank you, Ms. Riley. Mr. Bizer, you've saved time for a vote.
Can I ask you the same procedural question? If this court were somehow to find standing, does it go back then for a merits trial?
Your Honor, as this court is made very aware, the district court held that the courthouse violated the program access standard.
Right, that's why.
So, yeah, so, I'm sorry. I would argue that if the court follows O'Hare and Herman, then Dr. Crawford would have standing.
Right.
And the judge would take the information from the first trial and fashion an order of injunctive relief, because the court already found that we had a 2-day trial.
I understand all that. So is the point then that this court does not reach the merits in this appeal? Even if we were to find standing, the state is correct, or the county, sorry, is correct, that this then goes back to the district court for merits proceedings, and if the state were to get the same result from the district court, the same language, at that point the state would be entitled to come back here to have a merits appeal.
So I would argue that we already had a 2-day trial where Dr. Crawford was there for both days, the full days, and
I guess what I'm asking really is, I'm sorry to cut you off, are we here to deal with the merits as well as standing in this appeal?
No, Your Honor. We appealed. We're the appellants, and we appealed on standing. The appellee
They don't appear to be arguing for affirmance in the alternative ground that they win on merits. They just said specifically, we go back to the trial. And sounds like you agree with that?
Your Honor, the appellee did not file a cross appeal on the issue of
Sure, although I assume they could be asking in theory, hypothetically, to affirm on alternative grounds.
I couldn't hear you, I'm sorry.
I apologize. I assume they could hypothetically ask us to affirm on alternative grounds.
Again, I say that again?
It sounds like they're saying just deal with standing. But in theory, they could have said, we win on standing, and even if we don't, this court should affirm on merits.
My argument, maybe I'm not understanding your question, I apologize. My argument is we had a 2-day trial, and after the 2-day trial, the judge looked at all the pictures of the doorknobs in the bathrooms and said, we violate program access. In fact, before we even got to the courthouse steps on summary judgment, we thought the case was going to be all about what is the injunctive relief that the district court will fashion. So all that information, right, is already on the record at the district court level. So I would argue that if this court finds standing, that it should be remanded to the district court to fashion whatever injunctive relief necessary so that the courthouse does achieve program access standard. And if the district court feels that only 4 of the 8 courtrooms should be modified and they should have a program that swaps it around in case there's wheelchair users, that's fine. We're willing to go. We walked into that trial with standing and with program access already in the bag, so to speak.
Do you agree then that in the event that we would reverse, find standing, send it back, you guys have this remedies discussion, the state then, if it wishes to, could come back and appeal with respect to all the merits questions?
I don't know if the state would have standing to appeal the merits. I can't answer that question. But what I would say is that they presented their defenses, and the district court held that their defenses did not succeed. So, for instance,
let me just ask. I'll point. Let me try to simplify it. Are you asking us to deal with the merits in this case, in this appeal, or just standing?
Just standing, Your Honor. Yeah. And
May I
just
ask you, Mr. Bizer?
Yes, Your Honor.
I'm sorry, I'm not stepping on the court's tail. May I ask you a hypothetical to clarify where you are on standing? if the courthouse had 8 courtrooms and 7 of them, let's put it differently, let's concede that there was only 1 of the 8 that your client had an issue with architecturally, design aspects. Are you contending your client would have standing to challenge the inability to access only 1 of the 8 courtrooms, even though the other 7 were perfectly accessible? Or are you defining the injury and the program more broadly as jury service simpliciter, regardless of which courtroom is used?
So we respect Title II's program access standard. And that's, are the programs and services readily accessible to wheelchair users in this case? And so if only, in your hypothetical, if only one of them were
8 courtrooms, 7 are perfectly ADA compliant, no issue, he can use them. 1 has issues that present a merits question. Is there standing?
I would argue that if they had a policy in place where if there is a wheelchair user identified and they said, oh, we have a wheelchair user, that means we will default to courtroom 2 because we know courtroom 1, we have no standing at all. We got nothing, right? Because that's what program access is all about under Title II.
Okay, fair enough. Thank you.
Thank you for your time. It was an honor. Thank you.
Thank you, Mr. Bizer. Your case is under submission. Next case.